The Supreme Court hasn't announced its next major gun case, but the next gun case is already being decided without them. Across the country, lower courts are quietly rewriting what the Second Amendment means, reaching opposite conclusions using the same Supreme Court rulings. That kind of chaos doesn't last. And when it reaches this level, the Supreme Court doesn't get to stay silent much longer. Over the last 2 years, the Supreme Court has handed down major Second Amendment decisions that were supposed to settle the law. Bruen changed the test. Rahimi clarified limits. Other cases reinforced the framework. Together, they were meant to bring order to gun law nationwide. Instead, they've exposed just how divided the lower courts really are. The Supreme Court told judges exactly what to do. Stop balancing interests. Stop deferring to policy arguments. Stop weighing public safety against constitutional rights. Ask one question and one question only. Is the modern gun law consistent with the nation's historical tradition of firearm regulation? On paper, that sounds simple. In practice, it's where everything is breaking down. Some courts are taking that instruction seriously. They demand real historical analogs. They scrutinize the record. And when the government can't justify a restriction using history, those courts strike it down. Other courts are doing something very different. They repeat the Supreme Court's words, then reach the same conclusions they reached before Bruen ever existed. They rely on broad labels like dangerousness. They stretch historical examples beyond recognition. Or they declare the history unclear, then uphold the law anyway. The result is a growing split that the Supreme Court cannot ignore forever. One of the biggest unresolved issues driving this conflict is who the government is allowed to disarm. Not because of what someone did, but because of who the government says they are. Nonviolent felons, people under restraining orders, individuals accused but not convicted of crimes, people categorized as risky based on status rather than conduct. These cases are moving through the courts right now, and the answers don't line up. Some appellate courts say history supports disarming only those who were actively dangerous. Others say legislatures can define dangerousness however they want. Those two positions cannot coexist in a constitutional system. Another issue quietly building pressure is sensitive places. The Supreme Court acknowledged that sensitive places exist, but it never said they could be everywhere. After Bruen, some states responded by expanding sensitive place designations so broadly that lawful carry becomes nearly impossible. Transportation systems, entire categories of private businesses, large portions of cities. Some courts have pushed back, others have allowed it. That means the Second Amendment now means different things depending on geography. And that's exactly the kind of constitutional inconsistency the Supreme Court usually steps in to resolve. There's also a deeper institutional problem underneath all of this: compliance. Lower courts are required to follow Supreme Court precedent, but increasingly, some rulings read like attempts to work around it. The language of obedience is there, but the substance isn't. When that happens repeatedly, it creates a legitimacy problem, not just for gun law, but for the judiciary itself. The Supreme Court has faced this before in other areas of constitutional law, and history shows a pattern. When lower courts resist a new rule, the court eventually responds. Sometimes narrowly, sometimes forcefully, but it responds. What makes the next gun case especially important is that the groundwork has already been laid. This won't be about inventing a new test. It will be about enforcing the one that already exists. The justices will be deciding whether their instructions are binding rules or flexible suggestions. That decision will shape Second Amendment litigation for years, possibly decades, and the pressure to make it is increasing. Circuit splits are widening, states are pushing boundaries, litigants are forcing the same questions back to the court again and again. At some point, denial becomes impossible. When the Supreme Court takes the next case, it will likely be narrower than Bruen. But narrower doesn't mean less important. In many ways, it may matter more, because it will decide whether constitutional rights depend on conduct or status, whether historical analysis has real teeth, and whether lower courts are expected to follow the rules even when they don't like the result. So while the headlines focus on cases already decided, the real story is unfolding quietly. in district courts, in appellate panels, in dissents openly calling for Supreme Court intervention. The next major gun case isn't coming out of nowhere, it's being built by the system itself. And when it finally arrives, it won't just resolve one law. It will tell us whether the Supreme Court means what it says, and whether the Second Amendment has settled rules, or whether it's still being fought over, one courtroom at a time. That answer is coming, even if the case name isn't here yet.